Zephany Nurse's family is satisfied with the guilty verdict handed down to the woman who kidnapped their daughter in 1997. Zephany was taken from a sleeping mother's arm at Groote Hospital when she was just 3 days old. Well, let's unpack the case now with Dr. James Grant from the Wits School of Law. He joins us now via Skype. Dr. Grant, good morning. This case has really grabbed the imagination of South Africa and parts of the world because involving two families and a young baby who was taken away. From what Judge Hlophe was saying earlier this week, I mean, the credibility of the witness was really clear for him that the witness could not be trusted.
Yes, that's correct. If I may just correct you very briefly, I'm no longer at Wits Law School. I'm at the JOHANNESBURG Advocates Bar. Yes, he did reject the evidence given by the accused quite significantly. I think it was an interesting way in which he did so because he gave that indication the day before he gave his judgment. In fact, as I understand it from media reports, he gave his indication that he rejected the credibility of the accused during the summing up and argument of defense counsel, which is not altogether ordinary.
Yeah, when you look at this thing, I mean, not really ordinary. We were chatting with colleagues off air the other day to say the woman who kidnapped Zephany Nurse, who's now been found guilty of that kidnapping, plus fraud and also against violating the Children's Act,
yes,
was acting, I mean, out of desperation, but it doesn't excuse the crime. And of course, the Nurse family are quite happy with the verdict.
Yes, of course, there's always a massive difference between being able to understand a crime and the level of desperation that the accused must have acted with. But of course, that doesn't translate in our law to a valid excuse. And there regrettably must be consequences. And yes, as I understand it, the family of Zephany Nurse is very satisfied with this judgment.
Yeah, the accused has now been remanded in custody, so to speak, until sentencing is going to be handed down next month. The kind of sentencing jail time she might face, I mean, there are three charges here. There's one of kidnapping, there's one of fraud in terms of the fraudulent attainment of a birth certificate, and of course the Children's Act on its own. What kind of term could she be facing here, Dr. Grant?
Well, if we just take each in turn, there's in respect of kidnapping, it's a very serious offence, but there's no minimum sentence in respect of kidnapping unless a firearm was used, and of course in this case there wasn't. In respect of fraud, there's no minimum sentence unless the amount involved, given that it was a single offender, would be in a value of more than 500,000 rand. And as we understand it, the fraud that was perpetrated was in respect of the obtaining of birth certificates. And so there wasn't really an amount involved at all. And so the minimum sentence there wouldn't apply. And I'm not entirely familiar with which sections of the Child Care Act were contravened, but there certainly aren't any minimum sentences prescribed in the Minimum Sentencing Act for child stealing. Sorry, for not child stealing, for contraventions of the Children's Act. So we're in a position where the judge is really given full discretion, and he will have to take account of what we call the triad in Zin, the three critical considerations, the circumstances of the offender, and so there he will take account of the desperation with which he acted, the gravity of the offence. Of course, these are serious offences, and then the considerations and concerns of the community. Those three are effectively the various factors that he must weigh up. But we could be looking at a sentence, I would guess, an effective sentence of between 10 and 20 years.
Now, Dr. Grant, the fact that the defense was saying that there was no evidence presented in court that could prove beyond reasonable doubt that the accused was actually at the Groote Hospital in 1997, could the judge consider that?
He clearly did consider that. I think it's common cause. Everybody agrees there was no direct evidence of her taking the child, and so we were left, as I understand it, with circumstantial evidence. And often circumstantial evidence is dismissed as if it must necessarily be weaker than direct evidence being where somebody, for instance, saw the accused take the child, whereas with circumstantial evidence we're left having to draw inferences. But there are very real circumstances where circumstantial evidence is possibly more powerful than direct evidence, because we are coming to understand now that direct evidence and what people claim to have seen is also subject to some question. And so therefore circumstantial evidence, such as the sort presented where, for instance, in this case, another witness gave testimony that she in fact saw the accused around the hospital at the relevant time, that would be circumstantial evidence from which a strong inference can be drawn that she was in fact in that hospital, contrary to what the accused is saying.
Okay, thank you very much. That's Dr. James Grant from the Johannesburg Bar.